Hello, everyone, and welcome to the LAOT podcast. I'm Arnav Mathur, an editor at LAOT, and today we are diving into an issue that has become one of the most important constitutional developments of this year. This is the special intensive revision exercise that was undertaken in Bihar and is now being rolled out in several states as well. To help us unpack what happened, what it means, and where it takes us in the future of electoral governance in India, we have with us Mr. Satya Prasoon. He is an alumnus of NUJS Law School and has an LLM from Melbourne Law School. He is currently an assistant professor at Nalsar University of Law, and his work spans constitutional law, administrative law, and democratic theory, which makes him the perfect person to help us make sense of this moment. First, I'll start with giving a brief background of what has happened and laying down some important provisions that all of us need to understand before we start interrogating this exercise. So, there are two sets of questions and four provisions that really lay the groundwork for our conversation today. The first question is, where does the ECI source the power to conduct the SIR? On this point, the two provisions are firstly, Article 324 of the Indian Constitution and Section 21 of the Representation of People Act 1950. 324 vests the ECI with superintendent's direction and control over elections in India. 21 of the RPA empowers the ECI to prepare and revise the electoral rolls. So that's the first set of provisions that are important. The second set of provisions that are important for our conversation deal with eligibility and disqualification of voters in the electoral roll. So here we have Article 326 of the Indian Constitution and Section 16 of the RPA. 326 states that any person above the age of 18 has a right to vote. Section 16 lays down the criteria of when a person is disqualified from being a voter. These criteria include not being a citizen of India, being of unsound mind, or being disqualified from voting under a law related to corruption or election offenses. So this really sets the background and the context in terms of provisions that are important. Once the ECI released this notification that they're going to conduct an SIR in Bihar, almost immediately in early July, the Association for Democratic Reforms, which is headed by Senior Advocate Prashant Bhushan and Yogendra Yadav, who's a Swaraj Party member, they moved the Supreme Court under Article 32, challenging this notification. Amongst different grounds that they take, one of it is that the SIR is arbitrary, it's violative of the universal right of adult suffrage, and that it introduces citizenship-linked checks and seeks documents that the RPA does not account for. So now let me begin by asking what seems to be one of the most obvious starting points. The SIR, we know, was pitched as a pre-election hygiene exercise. You want to clean up the rolls before Bihar went to polls. Now those elections are over. So, Satya, the question really is, if the original justification has expired, what exactly is at stake here? And what is the ultimate relief that the Supreme Court could even grant in context of Bihar?
Thank you. Thank you, Arnav. Uh, Thank you for inviting me to this conversation. Uh, Now, responding to your question, my tracking of the response of the court to the challenge of SIR, my impression is that it seems unlikely that the court will decide against the authority of the Election Commission to conduct SIR. Till now, the interventions of the court have focused on taming or disciplining the implementation of SIR to factor in chances of disenfranchisement of marginalized sections from unlettered citizens to religious and gender minorities. Now, this is evidenced by the court uh, in directing the ECI to include Aadhaar cards as one of the enumerated documents to be considered. But I think looking at the proceedings in the court has to uh, more deeply factor in the gap that can be created between democracy and democratic participation with such bureaucratic weaponization, wherein one go voters post 2003 have been considered ineligible unless they satisfy the bureaucracy of being citizen voters through a non-transparent and expedited process. The
Right.
onus of satisfying the bureaucratic machinery that citizens are eligible voters leads to what anthropologist Nafis Ahmed has termed as citizen labor, which makes
Hmm.
the right to vote such an onerous process filled with fear and tentativeness that the merciless process can lead to great widening of gulf between democracy and democratic participation and representation. Now, coming back to your
Right.
question, uh, the rolling out of SIR in other states, especially Bengal, can open up more serious constitutional questions which have not come before the court in Bihar's SIR process. I'll
Hmm.
point towards one such constitutional question, which is the authority of the Election Commission to deregister voters or purge voters on ground of them being suspected illegal immigrants. Now, the
Right.
power to decide on citizenship question flows from parliamentary legislation on Citizenship Act, citizenship rules, Foreigners Act, and Foreigners Tribunal rules. But it is
Hmm.
feared that, and we are seeing reportage of that nature, that in Bengal there can be mass purging of voters from electoral roll on ground of them being illegal immigrants.
Hmm.
Now, this is a concerning moment because there seems to be conflation of role where the commission is in effect deciding the citizenship status of residents, which was neither intended by the Constituent Assembly, nor does it flow from the statutory regime, and it definitely does not flow from this kind of amorphous process of SIR,
Hmm.
which does not have a clear statutory backing, and even if it has slim statutory backing in Representation of People Act, it is functioning in a very untamed manner without any rules or notifications under electoral rules of 1960. So I think
Right.
this exercise of this power by election commission, where election commission is revising the role, or in or if I can phrase it differently, where the election commission is masquerading its role in just revising the role, but
Hmm.
in effect is in a way indirectly putting a question mark on the citizenship status, can throw up more provocative questions if
Hmm.
the court continues to hear this challenge
Right.
in light of the rolling out of SIR in more states in phase two of SIR.
Understood. Uh, so what I've understood in terms of the stake that we're looking at in this particular case, it's not just a Bihar specific administrative problem. It's being used as a template to then go out to different states like Bengal, Tamil Nadu, Puducherry to conduct a similar exercise. And it was interesting that you pointed out that the court in its proceedings itself seems to be just trying to tame the ECI and not really put any real safeguards. And you've thrown light on like different facets of the problem that I really want to interrogate. The first facet seems to be of whether the ECI even has the power to conduct an SIR in the first place. The second facet is uh, whether the ECI is de facto deciding your citizenship status in guise of putting you in on the electoral roll. And the third facet seems to be like, what was the ECI even meant to do? Right? So we look at all three of them, but at the heart of the dispute seems to be that does the ECI have the power to conduct an SIR? Now, in the RPA, it only recognizes two kinds of revisions. You have summary revisions and intensive revisions. What the ECI has now done is introduce something completely novel, which is special intensive revision. And this category does not find any backing, be it in acts or the rules. The defense that the ECI has taken is that Section 21, subsection 3, is a kind of a reservoir of power for it. It gives it broad discretion to conduct a revision in any manner that it may direct. So the core question is, does the ECI have power to conduct the SIR in the first place? How would you respond to that?
Thank you for a very thoughtful question. So specifically, the legal framework for electoral revision can be traced to Section 21 of Representation of People's Act, as well as the Registration of Electoral Rules 1960. Now, under Section 21 of Representations of People's Act 1950, the ECI is mandated to revise electoral rules before each election cycle.
Yep.
And here specifically, three types of electoral revisions are envisaged under Rule 25 of Registration of Electoral Rules 1960. These three types of electoral revisions are intensive revision, summary revision, and the third one is part intensive and part summary revision. This is given under Rule 25 of Registration of Electoral Rules. Now, this nomenclature of Special Intensive Revision or SIR has been unleashed for the first time by the Election Commission. Now, the Election Commission has argued before the court, as you have rightly mentioned, that it traces this authority or power to Section 21 of Representation of People's Act that says, and I am quoting, notwithstanding anything contained in subsection 2, the Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency or part of a constituency in such manner as it may think fit. So it is saying that the broad power to conduct special intensive revision can be traced back to Section 21 of Representation of People's Act. Now, if you look at the provision, it is very clear that this seems to be a very contingency and emergency kind of provision. So, but my belief is that the manner in which Election Commission has issued the notice about SIR, not through any notification or rules, but through a PIB release, and then has cited no special reasons that necessitated SIR and gave very wide, generic, cavalier reasons of rapid urbanization, frequent migration, young citizens becoming eligible to vote, or inclusion of names of foreign illegal immigrants. These are the reasons that they have cited, which could arguably be tackled by summary or intensive revision also. So all of this casts doubts on the legality of such an administrative exercise. Now, I just want to highlight that one of the reasons cited by the Election Commission of exclusion of illegal immigrants to justify SIR, this needs some unpack. Now, the determination of illegal immigrant is the remit of foreign tribunal functioning under Foreigners Act and Citizenship Act, as I had mentioned. The Election Commission's role, as one would understand it, is to work with the electoral roll and account for discrepancy maybe due to death or migration or residency or age or addition to electoral list. Now, this maneuvering of deletion of voters on suspicion of citizenship, if done under special intensive revision procedure without any rules or special reasons, mark, I think, a very, very dangerous turn for democratic participation in the country. Now, some commentators, especially the previous election commissioner, Ashok Lavasha, has termed it as an NRC exercise through the back door. So all of this, even if one can say that there is power given to the
Hmm.
election commission to conduct special intensive revision exercise, then also the exercise of power for it to be lawful has to be within the boundaries of the law.
Correct.
And this is where I think the court needs to probe this question more deeply about the legality of SI.
Understood. Right. So, I think it was good that you extracted the entire provision itself, and that deals with some sort of an emergency situation. But the reasons that the ECI has given seem to be obvious and exactly what it's supposed to do in a normal situation as well. And I think the moment you start, the moment any state in India or any political state in India starts demanding, layered documents like birth certificates, parental records, legacy papers, to me, there's a larger political memory that instantly gets activated, which is the CA NRC and the anxieties that were around CA NRC. This is something that, of course, you mentioned, but before we get into whether how similar or dissimilar CA NRC is to the SIR, I want to ask a different question. Where and how should the line be drawn between verifying your residence and age, which is admittedly the ECI's domain, versus verifying citizenship? Because we know that in the constitution itself, one of the disqualifications is that you are not a citizen of India. So, how would you want to draw this line of what is ECI's power and what is not ECI's power?
Mm, I think you are touching upon a very important point as to because over what we have seen is that there seems to be an expansionist role played by the election commission in
Hmm.
so far as it insofar as that it is not just preparing the electoral rules, or it is
Hmm.
not just ensuring that there is a fair election that is being conducted and being provided uh, uh, parties are being provided a level playing field. But insofar as it says that there has to be its role is also that of advocacy and ensuring that people know as to how they why right to voting has to be valued. And
Hmm.
even if all of these seems to be laudable aspects, we see
Right.
that suddenly something like SIR comes, which in which a lot of legacy documents are also being demanded. So
Hmm.
we have to exactly think about and relook as to what is the mandate of the election commission and which are the provisions that through under which these powers can be cited. So
Right.
your question is with regard to this conflation only, which is that
Correct.
is the role of election commission is to verify documents to ensure that there is integrity which is maintained in the electoral list, or does it go into a more deeper inquiry on who is being registered under what condition, and are also questioning the documents, previous documents through which they have become voters or they are eligible to become voters. So
Right.
that's a question that has to be thought about. But
Hmm.
in this process only, I think uh, I think this expansion in the power of election commission needs to be relooked carefully now that we
Hmm.
have the SIR exercise. Now,
Right.
as I mentioned, that principally drawing from Article 324 of the Constitution, the EC has power of superintendence, direction, and control with regard to only three functions: to prepare
Okay.
electoral rolls, to conduct elections, and to provide a level playing field for electoral candidates. Now,
Right.
if we focus on the first function, which is
Hmm.
preparation of electoral rolls, which seems to be under question, it would be safe to argue that revision of electoral roll has to be with an aim to account for change in residence, age, death, or birth of new voters. and
Hmm.
not with an aim to presume individuals to be non-citizens or illegal immigrants and then purge their name from electoral rolls. There is a
Correct.
system of statutory and parliamentary oversight that governs the determination of citizenship, and it is not within the remit of the election. However,
Understood.
one of the cited reasons by Election Commission to conduct SIR is to delete names of suspected illegal immigrants, and this you will find in the PIB release. And
Right.
this needs to be questioned robustly.
Hmm.
However, how did we reach till this point of time where the Election Commission is uh, freely citing reasons of illegal immigration as a
Right.
ground for conducting SI? How did we reach this point? So here I
Exactly. I think.
said that this is on the
Yeah.
strength of the jurisprudence of Supreme Court cases. Especially, I would want to
Hmm.
mention two cases. The
Hmm.
first case is Indrajit Barua in 1984,
Hmm.
and then Lal Babu Hussain in 1995. That
Yes.
has led to such expansion in the power of election commission. Now,
Right.
allow me to very briefly tell you the stakes of these two cases. In
Yes.
Indrajit Barua, uh, which was decided in context of immigration in Assam in 1980s, 1984, the
Hmm.
Supreme Court had opined that the exercise of preparing electoral rolls by the Election Commission cannot be separated from Election Commission applying its mind to
Hmm.
determine the citizenship status of the residents. In simpler terms, it said that preparing of electoral rolls means that wherever election commission is required to look at or quiz or interrogate the bona fides of citizenship status of residents who have those documents, then
Right.
it comes within the remit of election commission. So this is when the first confession happens. This
Hmm.
opinion could be seen as also endorsement of expansionist authority of election commission to delete names from
Hmm.
voter list on suspicion of illegal immigration. To certain
Right.
extent, one can say that the Supreme Court blunted this power or the wide
Hmm.
remit that it had extended to the Election Commission in the next case in Lal Babu Hussain in
Hmm.
1995, where the Supreme Court struck down two Election Commission orders which had asked overwhelming population of Muslims who were
Hmm.
mostly slum dwellers living in some parts of Bombay and in Delhi to prove their
Yeah.
citizenship status through a very restrictive list of documents. In this case, the
Hmm.
Supreme Court had come down very heavily on uh, the Election Commission by saying that citizenship cannot be reduced to a narrow range of documents. But
Hmm.
the legacy continued because the court did not question the authority of the election commission to delete voters from the list
Hmm.
on suspicion of them being undocumented citizens. So here
Correct.
also some part of blame has to go to this these judgments where the court realized that for election commission to do its work in preparing the electoral roll, if it is signaling or if it is taking out voters name from the list on suspicion of them being citizens, on suspicion of them not being bona fide citizens, then that is part of the remit.
Hmm.
But if you ask what is my view, so I'll again specifically point it out that in my view, citizenship is a prerequisite for being a voter. But
Correct.
it is not within the remit of the election commission to
Hmm.
inquire into citizenship claims of residents in India and then take out their names on that basis.
Hmm.
And the revision of electoral roll cannot turn into a roving inquiry
Right.
spearheaded by the
Into
election
theirs.
commission and names from voter list are deleted on suspicion of them being undocumented citizens, because this will set a very dangerous precedent, as this
Hmm.
will to making it very difficult for millions of marginalized residents to prove their citizenship before the foreign tribunal if there is
Right.
already a finding
That you are not a
finding
citizen
by the
by any.
election commission that their names have been deleted due to them being suspected illegal immigrants. So
Right.
I'll stop here with my answer.
Yeah, I think there was a very comprehensive answer because you looked at what the remit of power is, what the Constitution gives the ACI in terms of its power and what the remit of it is, and how the Supreme Court through Lal Babu and Inderjeet has sort of diluted or allowed for a more expansionist administrative process to come into place. And it's also interesting that one point that you made that once there is a person who is deregistered on the rolls because he or she is a suspected foreigner or suspected of illegal immigration, then the job of the foreign tribunal becomes so easy. It's effectively just rubber stamping whatever the ECI has already done. And there, the safeguards that are available if you go in front of a foreigners tribunal, that those are better when compared to the ECI. So that's again an interesting point. And I think what it makes me think about is how we even got to this place. Because if we look at what the election commission was originally designed to be, if you look at the Constituent Assembly debates, the early manuals, the first electoral rolls that were produced in 1947 to 50, the philosophy previously was unmistakable. And this is what Ornat Sani's book, which is How India Became Democratic, also looks at. The state would go out and find the voter. The entire administrative imagination was built around inclusion rather than exclusion. And the entire machinery was built on the fact that every adult should be brought onto the rolls. But if we fast forward about 75 years, the SIR seems to flip that logic. You've talked about one of the aspects, which is the Supreme Court's jurisprudence that has allowed this to happen. But my question is, why and how has ECI's self conception changed over time? And what are the different types of factors that really explain the shift in how the ECI sees itself as a guarantor institution in our democracy?
Yeah, I think you're right. Now that you have framed this question, that if we look at the role of the election commission through the long arc of history,
Yeah.
then it would be safe to say uh, that the election commission has deviated from the founding days of the election commissioner to, and that that can explain that would be a safe estimate that there has been a
Yeah.
slide and it has deviated from uh, its from the days of from early years of 1950s. Now, as
Yeah.
Ornish Sani showed in her work, that
Mm.
the extraordinary length to which the chief election commissioner went to ensure
Mm.
last mile connectivity for citizens in preparing the
Yeah.
first electoral law. Just contrast this with SIR. At that point
Mm.
of time in 1950, it allowed for all kinds of documents to register people to electoral roll,
Mm.
which meant interpreting ordinarily resident very broadly to include even homeless people who slept on streets and pavements. Any
Mm.
proof of document that could have supported the bona fide of the citizens were accepted. And the most important contrast was that individuals did not stand in queues, but the state reached out to all individuals to include them in the
Yeah.
electoral. Now, contrast this with SIR, where the burden has fallen upon the citizens to
Mm.
submit the labyrinth of documents in a short window. Otherwise,
Mm.
their names will be deleted. The manner in which election commission has adopted a confrontational response to political parties and has
Mm.
even turned SIR litigation into an adversarial litigation, with
Mm.
resistance being shown to interim orders from the court, is very surprising to say the least. Now, remember, I'm bringing a pop cultural uh, reference that we all remember the movie Newton, where we
Yeah.
all lauded the effort of an election officer who went through the trouble of setting up polling station deep in the
mm,
forest of Bastar, so that 77, 75 or 76 tribal villagers could vote for the first time.
mm,
Now, the adversarial contrast this with the adversarial position by EC on a range
mm,
of issues, on not
mm,
releasing dissent or not releasing dissent note by a fellow election commissioner on model code of conduct violation,
mm.
fighting a court litigation, Supreme Court litigation, where it again resisted percentage increase in VVPAT verification,
Mm,
justifying reducing the timeline for electronic data storage from polling stations,
mm.
to, in this case, resisting the accommodation of more documents for voter verification. Now, I'll
Right.
just say that it has to look at the its own past performance and the credibility of the institution, which
Mm,
it has, and the legitimacy that it has earned over its stellar performance in the last 6 or 7 decades,
right.
and asks itself the question that that if that is a body that is mandated to ensure free and fair elections and to
Mm,
ensure that people are able to exercise their franchise in a meaningful manner, what
mm.
does this kind of adversarial position before the court does to its own image? I leave it at
Right. But sir, my question, it's beautifully that you've beautifully reconstructed how the slide and how that shift happens. But my question is why? Like, why do you think the ECI has changed its self-conception over time? Like, what were the pressures that were maybe put on the ECI or that it feels that it has to do in order for it to now act in an exclusionary manner with that exclusionary philosophy in place? Could you maybe have like some pressure points on the ECI that have allowed this to happen in the first place?
you. Now, I was deliberately trying to avoid this question because this goes into uh, a particular reading of history, but I'll not devote too much time on it, but I'll
That's
gently
okay.
point towards what I feel, and these are my personal views. Uh,
Yeah.
I think Ornith Sani's book is one way of looking at it, but if we
Hmm.
look at it historically, then another picture might also emerge, and I'll just point in that direction.
Yeah.
1950 is
That's
the time when we had a lot of migration
hmm.
of from Pakistan to India.
Hmm.
And generally, it was assumed that a certain kind of migration is happening with
Correct.
with a certain religious affiliation. Then the anxiety of the government to also show that not one person should be devoid of franchise can also be looked at in that light. That what is
Hmm.
the kind of migration that it was trying to accommodate,
Yeah.
and if it was proactive in
Hmm.
issuing in registering people on the electoral list.
Hmm.
Even at that point of time, I understand that the regime, that the statutory regime was not complete. People who migrated, they were given uh, long-term residency permits. But beyond all of this, also we have all studied the political question of citizenship at that moment to see that even in the
Hmm.
constitution there seems to be some kind of implicit bias on religion in how we read article 6 and 7 very different. Then I would
Hmm.
also want to point out that if we even look at say, if we look at in we know that there was a national register for Assam that was created.
Yes.
We know that there has been Assam Accord that has led
Hmm.
to immigration. Why is it? Generally, you will not find literature on this, but if we track the same logic,
Hmm.
then one would also think that if Assam Accord allowed for automatic uh, inclusion of immigrants as citizens who
Hmm.
came into Assam before 1965 and how it put onerous conditions between 1965 to 71. Generally, it was
Hmm.
seen that people who are coming from Assam are are
Right.
are people who have a particular religious affiliation, and that
Correct.
is a natural process of migration that has
Hmm.
continued since partition, and
Hmm.
that is why no questions will be asked. But the moment it became that people who might belong to another minority religion, their influx is coming. Suddenly you
Hmm.
see that there are onerous conditions that are put in Assam Accord. Compare this to to Indrajit Barua case. What was
Hmm.
Indrajit Barua case about? It was about the case that petitioners moved to the court that the election commission is not doing enough because there has
Hmm.
been influx of illegal immigrants into a lot of districts and it is not doing the intensive revision. And it is in that
Hmm.
context, what kind of migration was it feared?
Yeah.
Even if you link that 1980, even if you link Assam Accord to the
Hmm.
change in citizenship provision under Section 3, where the first amendment happened in
Yeah.
1987, where it said that if one is born in India, that is not enough to be given citizenship by birth. They have to
Hmm.
satisfy another requirement that either of the citizens have to be an uh,
Right.
Indian citizen. Now, this has to be linked to Assam Accord and has
Hmm.
to be seen in that historical context that if it is trying to flush out immigrants from 1965 where the accord has only been signed in 1985, the anxiety
Hmm.
is that Assam Accord will not reach its end unless we change the jus soli criteria to a jus sanguinis criteria. So in a way one can also say that the political deadlock in Assam
Hmm.
paved way and the anxiety about a certain kind of immigrant from a particular religion paved way
Hmm.
for gradual changing the principle of jus soli to jus sanguinis, which then continued in 2003. Why did it continue in
Right.
2003? Because Assam Accord, it was claimed that it is not being able to, the foreign tribunals that was functioning, it was not able to effectively flush out. And that is the term
Right.
I'm using it in a pejorative sense only. Because
Hmm.
the
Hmm.
claim used to be made that we have to flush out these
Yeah.
illegal immigrants. So another change was made in 2003 that what would
Hmm.
happen if one of the parent is an illegal immigrant. So the criteria was that both of the parents now have to be Indian citizens.
Yeah.
So I'm seeing that depending on how one reads history,
Hmm.
there can be and the election commission seems to be at the forefront of it because it is
Hmm.
an institution that is feeling these pressures. I am
Right.
not saying that it is doing it intentionally, but the
Hmm.
this kind of dog whistling that happens
Hmm.
on and the prefixes that are being used, which can be infiltrators, which can be termites, that robs a person individual of their personhood and
Yeah.
cancels them out by calling them alien, leads to this kind of psychology and changing of
Hmm.
constitutional identity gradually, where
Right.
the election commission, because it is seen as independent, it naturally assumes
Hmm.
that the voter list has to be correct. And it's not just the election commission. What justifies the Supreme Court not just which had to gatekeep the exercise of exclusion, where it spearheaded and led
So
from the
allow
front, where it was more executive than the executive in how the bench led by Gogoi and Rohinton Nariman.
it. Hmm.
It spearheaded the whole NRC exercise, where the government kept asking for more time, and
Hmm.
they said that they will initiate contempt motion against the government if they don't conduct this exercise.
Right.
So it's this kind of frenzy that has to be seen. But I was
Hmm.
resisting this question because it can give. This is the way I look.
Of course. Of course. No, I think the whole point of this podcast was to understand how you look at it, and you've captured how a different reading of history, and if you just try to put a lot of pieces of the puzzles together, a very completely different picture emerges. where the Bihar SIR and all these upcoming SIRs that we'll see, they they don't seem out of blue. They seem in line with the thread that has already been flowing through judgments, through executive actions, through political consciousness from 1950s to be not even like it's not even early. It's from 1950s that seed has then been planted, which is now continuing. And it almost seems obvious that the next step would be to get ECI under your supervision, to have ECI also perform the sort of tasks that the country is heading towards. So that is why I felt that probing this question would be really important for all of our listeners as well. Now, let's get back to the Constitution and let's look at what the constitutional status of is of right to be on an electoral roll, because we're looking at the revisions of electoral roll. So the natural question becomes that, okay, if I have a right to be on the electoral roll, is it a statutory right? Is it a constitutional right? One of the arguments that the petitioners have not seemed to be taken is a basic structure argument, saying that being on the electoral roll and the ECI's notification violates the basic structure of representative democracy. So, is that something that might be a possible argument, or what is generally the status of right to be on an electoral roll?
So I'll first tackle the question and clarify as to what
Hmm.
is the status of the right to be on electoral roll, and then come to the question of basic
Yeah.
structure. Uh, because the
Yeah.
first seems to be fairly well settled, and though it is very controversial, but I'll just say
Hmm.
how does the Supreme Court look? So the
Yeah.
position of the Supreme Court has been consistent in a series of judgments, starting
Hmm.
from Jyoti Basu in 1982 to Lily Thomas case in 2013 to Anup Banwal case very recently in 2023,
Correct.
that has held that right to vote is a mere statutory right and not a
Correct.
fundamental or constitutional right. In Lily
Hmm.
Thomas, if we read the case, then the court went on to even observe that voting is a privilege, which can be
Hmm.
taken away through a statute.
Hmm.
Now, if we read these judgments, the court seems to have taken a dichotomous stand in reading freedom to vote as a
Hmm.
facet of Article 19 while restricting or consigning the right to vote to being a mere statutory right.
Hmm.
Now, this brings us to the second part, which you asked about representative democracy. And here I'd
Yeah.
also say that the court also seriously needs to rethink this
Hmm.
dichotomous position where the court should try and understand this basic thing that if democracy is a basic feature of the constitution, then democracy
Hmm.
has to be seen as a bundle of rights
Right.
that resides in different laws and statutes and conventions. And protecting democracy or safeguarding democracy requires safeguarding not just the freedom to vote, but also safeguarding the independence of election commission,
Hmm.
recognizing the right to be on electoral votes, the protection being given to civil society to speak fearlessly without impunity,
Hmm.
and with not a, a very mechanical invocation of FCRA rules against NGOs. It also
Hmm.
requires, it also needs to apply the basic structure test to not just constitutional amendments, but the whole
Right.
architecture of laws wherein resides the bundle of rights that have
Hmm.
democratic content.
Right.
Uh, but since you asked me about the basic structure that could the petitioners did the petitioners uh, miss a route by not invoking the basic structure argument.
Yeah.
Now personally I'm a little although I think that in this present avatar, which means that the basic structure challenge is only applied to constitutional amendments and not to
Right.
laws and not to statutes or rules, this needs to be rethought. But
Hmm.
I think the latest jurisprudence that has come on question of unconstitutional constitutional amendments and constitutional identity. It
Right.
has critiqued the way the court has chiseled out basic structure of the Indian Constitution. And that is why I am a
Hmm.
little hesitant to apply it. I'll explain it to you very simply. And probably you'll understand what the court
Hmm.
has done is this. It has said that the constitutional identity of that the constitutional identity or the basic structure of the constitution are a range of are a range of principles which can be democracy, secularism. So it has
Right.
tried to find it historically. It has tried to embed all of it historically. But the question is this:
Hmm.
think about it. That constitutional identity or any sort of identity is always take shapes against the background of changing situations. This can be a very, very
Hmm.
disconcerting fact, but it changes. And the moment one
Right.
tries to freeze it, and we say that we have that basic features, even if our nation or polity is going in a different direction, these basic features have to be discovered and the essence is
Hmm.
embedded within it. It is a
Hmm.
problematic thing because I'll tell you what happens. If you look at uh, if you look at European constitutional identity, then a lot of these
Right.
countries from Poland to Hungary to Germany are invoking their past
Hmm.
constitutional identity in saying that
Hmm.
this is the essence of our constitutional identity, in saying that how the human rights standards that have been prescribed under European Human Rights Commission should not be applied because because our
Okay.
constitutional identity is frozen. So the point here
Hmm.
is this, that even in the way we invoke basic features would mean that we
Hmm.
have to look at basic features as in a manner as uh, theorists like Anthony Apaya uh, or I'm forgetting his name, or theorists like Jacqueline Neo or
Hmm.
uh, Gary Jacobson. Gary Jacobson has said that constitutional identity depends on is chiseled through a very disharmonious relationship or
Hmm.
dissonance between different provisions of the constitution and the text and the subtext of the constitution in with the larger context. So it is a slider scale.
Right.
Identity is forced just like
Yeah.
individual identity through all of these. So we can't say today
Also
that
changes over
that
time.
our
Yeah.
citizenship is, if that jus soli is the principle. Because
Hmm.
if we track the citizenship status from 1950 till Citizenship Act, you will say that there is this dissonance or disharmony between the text and the social and the political context, and this gives us some ground for
Right.
hope. I'll tell you why. Because this
Hmm.
means that the call for decolonization and which is being metamorphosed into a call for a certain kind of Indic civilization means that
Right.
all of these claims can be resisted by saying that it is upon the people
Hmm.
to bring it back through practice and figure out that what is the constitutional identity. So the way in which the court has said that these are the basic
Hmm.
features is something
Hmm.
that a lot of thinkers like people who have worked on India, Gary Jacobson,
Hmm.
Jacqueline Neo, or Rose Nye, there is a new way in
Hmm.
which basic structure doctrine is also being rethought. So that is why I am not pinning my hopes too much
Right.
on the older version in which it is applying those things.
That's very interesting. So I think I was really struck by a couple of points that you made. Firstly, about democracy being a bundle of rights that the courts really need to unpack and interrogate of what democracy means. Even if you look at the old version of the basic structure doctrine, and you say that okay, democracy is a basic structure and a fundamental feature of Indian jurisprudence and Indian constitutionalism, what does it in effect mean? that is something that I think should be brought out more in not just the literature but also by the courts. The second thing, of course, the whole idea of having a new understanding of basic structure doctrine, not seeing it as a fixed and unchanging, but having a more purposive interpretation given the recent times. I think that's really interesting. And the last piece of hope that you left all the listeners with, I think that's also amazing, where you need to rethink how basic structure doctrine should look like in the future and what sort of society we want for us in the future. So, we've spent, I think, this entire episode unpacking not just the special intensive revision in Bihar and the case that is being followed, but we also looked at uh, the election commission's understanding, how it has evolved, what has made it evolved. We've also looked at the the understanding of basic structure and how that should be changed over time, and of course focused on the Bihar SIR uh, exercise, whether it's legal or not, what is the remit of ECI's power. So thank you so much for that. And before we leave, I just have one final question. Where do we go from here? What do you think is the future when, specifically, of course, in the context our of India being an electoral democracy and the role of ECI within this entire system? Where do you think we'll end up, and where do you think we hope we end up?
Uh, thank you for that question. I think this is a very important question, but I, if you ask me in context of SIR, what I'll say is that whatever has panned out in the coup, uh, I
Hmm,
think I'm cautiously optimistic. I'll tell you my reasons for it. Uh, the
hmm,
Supreme Court, in choosing to hear the SIR, in a way, I can say as a continuing mandamus, is a decent start. Now, I am hopeful that
hmm.
now the process of SIR, which we know for certain, which will be rolled out in other states. Now, I hope
Yeah.
that the interim orders by the Supreme Court will act as check in taming and pruning the unaccountable nature of SIR. But
Hmm,
I expect more from the Supreme Court, and because of its past jurisprudence. So I think what is also needed from the
hmm,
Supreme Court is to hear this challenge squarely also as a
hmm.
constitutional and administrative law matter, where it settles the
Right.
question of legality of SIR as well as the
Hmm,
administrative law questions on the housing of SIR exercise under statute and rules. And
hmm.
this is important because the manner in which SIR is being rolled out in every possible state, there's nothing special about it. So if the
Yeah.
court is able to tame it under administrative law and send the message that
Hmm,
SIR requires special justificatory burden and cannot be
yeah.
undertaken in a routine manner with such onerous
Hmm,
requirements. Because these are
hmm.
onerous requirements that fundamentally changes the relationship between citizens and state. It changes
Yeah.
it from citizens and state to them being subjects and state. So I would be looking at
Hmm,
the case
hmm.
very carefully, and I think till now, at least I think the petitioners and the interveners have exhorted the courts to ask very tough questions to election commission. Uh, but
Hmm,
this is an exercise that I think needs more discussion, more critical engagement, not just in legal circle. And at the end of it,
yeah.
what I'll send is this case is about any case, any constitutional law case in my that I have seen.
Hmm,
I'll say that that is not about what review standards are invoked, how do you read the text, but it is about
hmm,
it is about capturing a certain kind of popular common sense on the ground. So it is what we the people bring to the court that allows for all
hmm.
of these malleable standards of judicial review to be put in service.
Right.
So the point that I'm trying to make
Right.
is that if there is a fear of disenfranchisement. I'm also saying that there is also a need for integrity of electoral rolls. This has to be a citizens
Hmm.
movement and civil society movement, because no matter we are reading constitutional law, but if we look at it in context, it all
Hmm.
important cases are about a certain kind of momentum and an argument, and the case is made outside of the court, where the court generally cloaks
Correct.
it in certain forms to think about the
Hmm.
various things. And this,
Yep.
my fear is that this case with has so many legalese or legalities that it
Yeah.
requires wider discussion, so that it is not seen as a narrow bureaucratic exercise, which
Yeah.
prevents that kind of popular discourse around the issue. So I'm seeing that a lot of responsibility is on the people to read
Yeah.
about it, think about it, look at the history, and then form their
Hmm.
own view as to how this can be
Yeah.
done in a more disciplined manner, without
Hmm.
making it without making a very important but simple task of voting a very, very onerous task.
Correct. Thank you. Thank you so much,
Hmm.
Satya sir, for taking out the time to be here. And I think the last point that you made, that it's up to the civil society and us as people to actually raise awareness and to think critically about this issue. That was really one of the reasons why we wanted to conduct this particular episode with you, because we hope that this gives a launch pad for future discussions and for future literature. And if not anything, it just makes people more informed about what is happening uh, vis-a-vis their rights to vote, which is one of the most fundamental and the most important right in any democracy. So thank you so much. We've covered a lot of grounds, and I hope that this is useful to anyone who's listening to us. Thank you once again, sir.
Thank you, Arna, and thank you for such thought-provoking questions, and asking such reflective questions, which was free of all the clutter that is surrounding the debate. And I think on most of the questions,
Yeah,
you were very succinctly able to capture the essence of my arguments. And I thoroughly enjoyed this very stimulating conversation with you. Thank you very much for inviting me
thank
to
you,
this
sir.
conversation. Thank you.
Thank you.